Good morning, ladies and gentlemen, boys and girls, to another exciting episode of iTuesday. Today's session is about the introduction to the HPCSA, and we are so grateful to have on our panel today Thea, who is our Mednal expert, together with Tarryn Venter, who is a senior associate at Clyde Co. So just a little bit about Tarryn. She's got an impressive resume, if I do say so myself. Tarryn assists numerous clients with defending litigated matters, responses, and appearances before regulatory bodies and policy responses. Her experience stems from her practical experience in the insurance sector, working for large-scale clients. Tarryn commenced the articles in 2012 and was admitted as an attorney in 2014. She is well established in dispute resolution. She obtained both her BCom Law and her LLB from the University of Pretoria. Go UP, whoop whoop. Some of Tarryn's experience, she successfully defended healthcare facility against substantial medical malpractice claims. She's defended numerous medical professionals against claims lodged against them at the Health Professions Council of South Africa, and she assists insured clients with the responses to the phase ombud. So Tarryn is well versed in what she's going to discuss. And Tarryn, without further ado, over to you.
Thank you so much, Ferguson. Sometimes I forget that giving away when I commenced my articles kind of gives away my age. So maybe we're going to have to change that. It's experience versus age here.
Age is nothing but a number.
I am going to share my screen with you. Sorry, let's just make sure that I'm sharing the right screen. Can everybody see, Ferguson, perhaps you can just confirm that you can see my screen just fine?
We can see your screen.
All right, fantastic. So good morning, everyone. Welcome, and thank you so much for joining me for this medically based session of iTuesday. As Ferguson's already advised, my name is Tarryn Venter, and I'm a senior associate over at Clyde Co. I'm joining you today from our new Johannesburg offices, although it's just a blurred background. Just a little bit about me in case we all haven't already met. I know that if we've met a few, but there are some new faces here today. I am an insurance attorney at heart, but I have a genuine passion for medical malpractice. I really do enjoy being able to assist practitioners going through a stressful process and to provide them with the necessary guidance and support. So let's dive right in. When dealing with medical practitioners in the regulatory space, it is important for us to know and understand the regulator with whom we are dealing so we can better understand the process and get a better understanding of the potential outcomes. So my very first question is then, who is the HPCSA? HPCSA is an abbreviation for the Health Professions Council of South Africa. The HPCSA is a statutory body that has been established in terms of Section 2.1 of the Health Professions Act. The HPCSA is currently comprised of 12 professional boards, and these professional boards include medical and dental, dietetics and nutrition, emergency care, and environmental health, just to name a few. As I'm sure that you're all aware, registration with the HPCSA is a prerequisite for practitioners to practice. Now, with that introduction to this body, let's move along for what we're really here for today, understanding the HPCSA's complaints process. The HPCSA's complaints process is set out in terms of the Health Professions Act, read together with certain regulations, and one particular regulation with a very long title, which reads, Regulations relating to the conduct of inquiries into alleged unprofessional conduct. So quite a mouthful. But considering that all this reading we have to do to understand the process, I think it's best explained in this diagram. Now, it might look a little bit complex at this stage, but I promise by the end of this session, you'll have a better understanding as to how this all works. So as a point of departure into the complex aspect of the HPCSA's complaints process, we need to evaluate the rules and standards against which practitioners are judged. specifically the Code of Ethics. While each discipline has a certain standard of practice that they are held to, there are certain ethical rules which all practitioners, irrespective of discipline, are required to adhere to. And in this regard, I refer you to the ethical and professional rules of the Health Professions Council of South Africa. So please don't be deceived by the image that you see on screen here. As much as it is noted as Booklet 2, the ethical and professional rules are actually regulations to the Health Professions Act, and they are gazetted. So as much as the HPCSA publishes, they've currently got 17 booklets that they've published, which provide guidance to practitioners in different sectors. So it'll be in relation to informed consent or patient records, and there's even one in relation to palliative care. Booklet 2 is ultimately the regulations by which practitioners are judged and held to. So you can see all these booklets on the HPCSA's website, and often they're quite a good starting point when you receive a complaint, because it gives a better understanding as to how the HPCSA expects its practitioners to behave. So the last point I want to make is that we also have to have regard to the National Health Act. That has to be, you have to have a look at the practitioner's conduct in conjunction with the National Health Act, as it does have a bearing. So there's a whole lot of regulatory framework that we have to bear in mind when dealing with HPCSA complaints. Furthermore, to ensure that healthcare practitioners are actually protecting themselves, we need to review the aspect of consent. As I'm sure you're all aware, when you respond to an HPCSA complaint, there will likely be some discussion in relation to the patient's medical treatment or perhaps even their condition. As such, it is vitally important that the medical practitioner must have received the patient's consent. So if you've seen one of these that's appearing on screen now, you've already seen an HPCSA complaint. But for those of you who haven't, this is the consent portion of the HPCSA's complaint form. When responding to the HPCSA complaint, we must ensure that this portion of the form is properly completed. And this is easy if the patient is also the complainant, because they will just sign this form here. However, issues arise where the complainant and the patient are two different people. So it's where the patient is actually a minor child who is over the age of 12, any other person who was a patient of the practitioner, or even a person who is now deceased. We need to make sure that this block is properly completed to ensure that the practitioner doesn't disclose confidential information. If it is not completed, we need to contact the HPCSA so that they can obtain the necessary consent. So what happens here is, we've often seen it where we get the complaint in and we say, go back to the HPCSA and say, thank you very much for the complaint. We acknowledge receipt. We've noted the date on which it is due. However, we've noted that the consent form is actually incomplete. Please can you obtain consent from the patient so that we may submit? And the HPCSA may or may not be able to get the consent timeously. So then on the due date, we then go back and say, we've noted that the response is due today. The response has been prepared. We are ready to submit. However, we are unable to do so until such time as consent is obtained. And then you put the ball back in the HPCSA's court to ensure that they obtain the necessary consent to allow the practitioner to respond. So just before we move on to how the complaints process works, I think it's important to take into account the policy that we're dealing with today, specifically the I2 medical malpractice policy for medical professionals. So the policy actually covers costs associated with HPCSA complaints, and the policy wording reads, the insurer will indemnify the insured for all fees, costs, and expenses incurred with the prior written consent of the insurer in assisting and representing the insured, or incurred by the insured in respect of any HPCSA regulatory or disciplinary inquiry or process. So therefore, you can see here that I2 will cover the fees, costs, and expenses relating to a response to the HPCSA complaint, together with any additional aspects that follow that, but it must fall within the confines of the policy wording. And as you can see from my slide, I've added my own emphasis here because I think it's important to highlight that this is with I2's written or prior written consent. And as such, I2 must be notified of the complaint as soon as possible after the practitioner has received it. The reason for this is not only for I2 to be able to confirm cover, but it's to ensure that everyone's rights are protected and to ensure that the practitioner receives the best possible representation for his or her complaint. So let's move on now to how the complaint process works. So when the HPCSA's complaints department receives a complaint, it is submitted to the registrar, who must then record the complaint against the practitioner's name in the register that is kept. And just like the rest of us, even the HPCSA is moving more away from paper and is going more digital, as they actually record the complaint against the practitioner's name in the login portal on the HPCSA's website. So they can check there if they have any outstanding complaints. But the registrar must then also categorize the complaints by significance and seriousness, and then refer all minor transgressions to the HPCSA's ombudsman. So you can see here on the screen, we're first dealing with the ombudsman in terms of Regulation 3. So in this regard, allow me to introduce you to the HPCSA's ombudsman, Dr. Quinder. So where matters are referred to the ombudsman, Dr. Quinder is required to either mediate the matter, refer cases that could not be resolved through mediation back to the registrar for preliminary investigation, refer matters not falling under the jurisdiction of the council to the appropriate bodies or tribunals and inform the complainant accordingly. So what happens here is this is where you get complaints in relation to homeopaths or chiropractors who are actually registered with the Allied Health Professions Council, or even perhaps a nurse who's registered with SANC. Those complaints have to go to the relevant bodies, and then the ombudsman will inform the complainant that it has been transferred. So now, when we're dealing with the ombudsman, we're ultimately dealing with minor transgressions. But you may ask, what is a minor transgression? What constitutes a minor transgression? Well, isn't this just the million-dollar question? So minor transgression is defined in the regulations as conduct, which in the opinion of the registrar or preliminary committee of inquiry, on the basis of the documents submitted to the registrar or such committee, is unprofessional, but of a minor nature, and does not warrant the holding of a formal professional conduct inquiry. So as you can tell, the definition is rather vague, and therefore it is ultimately up to the registrar to determine what constitutes a minor transgression. In practice, what we've seen is a minor transgression relates more to sort of billing complaints. And I'm not talking about fraud. I'm talking about actual billing complaints where the complainant will say, oh, the practitioner's charged me too much for this, or I'm unhappy with this charge, or the practitioner's handed me over to an attorney to collect fees. So we see complaints like that are generally considered to be minor transgressions, or where there's been a poor interaction between the complainant and the practitioner. So that's when it generally becomes a he said, she said incident. So the positive part of this process, and we're all looking for silver linings at the moment, is that as the name confers, minor transgression generally is of a less severe nature than those complaints that are referred directly to the preliminary committee of inquiry. So the consequences are not as severe. Right. So once the ombudsman has received a complaint, he can call for further information from the practitioner involved. This normally happens from a practical standpoint where the practitioner receives an email from the ombudsman advising that this complaint has been lodged and the practitioner has 10 days in which to respond. Now, as much as that 10 days is provided by the ombudsman is not unreasonable, and you can always ask for an extension, especially where there's a reason for it. You know, the practitioner back in the day was at Congress or is on sick leave, or whatever the case is, and you just say to the ombudsman, we apologize, we intend to respond, but we do need more time. It's generally not frowned upon, so that's quite easy to deal with. So once the practitioner has now submitted a response, the ombudsman can either make a determination in writing, essentially where the ombudsman comes back and says, thank you, considered the response, I'm happy that the practitioner did what they were required to do, and the matter is considered to be finalized. Or the ombudsman can actually refer it to mediation, where the parties are invited to sit and discuss the matter. If it comes out that the complaint is actually of a more serious nature, then the ombudsman can refer it back to the prelim committee of inquiry for further investigation. So, should the matter be referred to mediation, then the medical practitioner and the complainant are required to attend a meeting to discuss their versions of the complaint. Now, pre-COVID times, we used to all go down to Emperor's Palace and sit and wait our turn to be called so we could have a discussion about the matter. But this has changed with the times. And again, silver linings for the pandemic was that we've all been forced to use technology a bit more, and the HPCSA has taken this to heart. So we're now conducting mediations by way of MS Teams. So ultimately we get an invite, and again, it's not hard and fast. If the practitioner is unable to attend on a specific day, we ask for an alternative day. We then are allocated a time slot of about 20 minutes, and we then go to discuss the matter. Now, what's important to note here is that the practitioner or the complainant can take anybody in who can support their version. So we've seen it before with practitioners where there's been another doctor involved in the treatment of the patient, and therefore that doctor gets taken in with the practitioner. And on the side of the complainant, perhaps their spouse was present at the time of the incident, or someone else that can actually support their version, and they are allowed to take that person with. Now, legal representation is also allowed for the practitioner, but we are there in purely an observation capacity. We're not there to interfere or get involved with the process. It's just so that we better understand what the complaint is, so that if we need to address it at a later stage, we can. So ultimately, we then all go through the mediation process. And I must say that legal practitioners, or I've been known to interject if I feel that there's an issue such as confidentiality or where the practitioner may unduly prejudice him or herself. So we do interject when it's necessary. But now through the mediation process, ultimately, Dr. Quinda hears out both parties, and at the end really likes the parties to apologize to one another for any insult that may have been caused and for the matter to be closed. Now, sometimes the process works and sometimes it doesn't. So going back to the process, where there's a final determination made by the ombudsman or where the mediation is successful, both parties must agree to abide by the final outcome. So they must say, yes, I agree that the matter be closed. But should one of the parties, it can be either the practitioner or the complainant, refuse to abide by the final outcome, or should the mediation fail, then the complaint is referred back to the Committee of Preliminary Inquiry for further investigation and determination. What is of importance here, though, is that any information disclosed to the ombudsman, either in the response or during the mediation process, is confidential and privileged, and as such, the prelim committee then has to consider the matter afresh, which is quite nice because the complaint itself doesn't change. The complaint is submitted as it was submitted to the ombudsman, but then the practitioner has to respond to it a second time. We usually use the basis of the response to the ombudsman, but then embellish, because after the mediation process, we certainly understand a bit better as to what further complaints could be raised, and we address those. So the process can be quite helpful. But now we have reached the more serious portion of the complaints process, where a complaint is referred to the Preliminary Committee of Inquiry, or Prelim Committee for short. Remember that this referral can be either at the outset by the registrar, or it can come back via the ombudsman. But I would just like to take you on a short detour down the route of a Section 41A investigation, which the registrar can call for if the registrar is of the view that further information is required. So for this investigation, a person is appointed by the registrar and is given powers in terms of the Act. They are then provided with a shiny certificate, and this enables them to attend to the necessary investigations. These investigations can, however, present quite a challenge for practitioners as they are done without any notice. So we've got two scenarios here. So on occasion, the practitioner may not actually be present in their rooms. These authoritative figures stride in and they say to the receptionist, we are entitled to see the following documents and take pictures thereof. The receptionist can often get quite flustered because these people are from the HPCSA and she doesn't want to get the practitioner into trouble. So she hands over whatever they ask for. And this is given without context. So the investigators then don't get a version from the practitioner themselves. They take pictures of the documents and they leave. It can pose quite a problem because then the practitioner is actually not too sure what they were there for or what they were looking for. But then you've got it on the other hand, where the investigators show up and the practitioner is there and they're asked to interview the practitioner. And they sit down and they ask certain questions. And the practitioner perhaps divulges the information in a way that is not necessarily phrased correctly. And this can often land them in more hot water than perhaps providing a written response. Obviously, that option is not available to them at that stage, but sometimes they're caught so off guard and they're just looking to comply and to try and be helpful that they actually give more information than what is required. And it does often get them into trouble. So what happens is once the investigators have completed their investigations, they take all this information away and they go and prepare an investigation report. And that investigation report then stands as the complaint against the practitioner. So just as a practical example, I've had one of these recently where the investigators went into the practitioner's rooms on the basis of an employer's complaint that was submitted against the practitioner. Now, just to give a bit of background to that, the employer had received a sick note from an employee and wasn't happy with the sick note and submitted a complaint to the HPCSA saying that they weren't happy. And the HPCSA then took that complaint and granted powers to the investigators to go and investigate the complaint. So they interviewed the practitioner, and the practitioner, as I say, just provided information, not necessarily that was incorrect, but perhaps provided it in a manner that didn't really speak to the truth of the matter. I'm not saying that they're lying, it's just that the phrasing wasn't necessarily correct. And based on that information that the investigators obtained, they actually then went and wrote a report and found that the practitioner had transgressed certain HPCSA rules and that the practitioner would now have to respond to that. So then the investigation report itself, as opposed to, say, the employer's complaint, stands as the complaint against the practitioner. So then you have essentially two types of complaints. You have the complaint that is submitted by the complainant or the Section 41A investigation report. Apologies, my slides were a little bit slow there. So now I'm going to move you on to another slide. Now the complaint is available. It's, as I say, it's either the complaint that is submitted by the complainant or in terms of the Section 41A investigation report. So when a complaint is then referred to the prelim committee, the prelim committee must request a written response from the practitioner in question within 40 working days. The HPCSA ordinarily calculates these days for you and includes it on their covering letter where they request a response from the practitioner. As I've said previously, the investigators can be asked for an extension as long as it's reasonable and it can't be too lengthy. I've had some who have granted me 2 weeks and others who will only grant me a week. So it really just depends, but we ask very nicely and often they are obliging. So once the practitioner has been called upon to respond, the ideal process is that the practitioner notifies their broker, who then notifies I2, who then confirms cover and provides the complaint to a legal practitioner or an attorney, who then contacts the practitioner and discusses the complaint with them. We usually go through the complaint step by step. We ask them to tell us about the patient, about the interaction, provide us with your clinical notes, consent forms, anything that may be of relevance, and we walk them through the process. Once we have their full version, we then prepare a response to the HPCSA. I must say that I do not submit that response unless my practitioner is 100% happy with what is being provided, because ultimately it is their version and they have to stand by that version. So that's why we make sure that they are absolutely happy before it is submitted. So now we've gotten to the place where we've submitted the complaint timeously or the response timeously, and it's now before the preliminary committee for adjudication. The prelim committee can then do one of two things. They can either make a determination on the basis of the documents before them, or they can call for a consultation. So this is like another detour. I'd just like to make it clear that consultations do not happen for each and every matter, but it's normally where the prelim committee says actually they need a bit more information or clarification from the practitioner themselves. So again, the practitioner is invited to attend the consultation, and it's also held on MS Teams. Previously, what used to happen was we would all sit in a line, a line without spacing between us, as opposed to now. We'd all sit in a line in Emperor's Palace and wait for our name and matter to be called so we could go in, and that process could take forever. But now the process is much easier because we get given a time slot and the investigator calls you sort of 2 minutes before and says, I need you to log in now, and then we will let you in. And the consultation generally takes about 15 to 30 minutes, somewhere there. But what we do prior to these consultations is we actually prepare the practitioner. We go through their version of the response. We just address and highlight certain points that the committee may pick up on, that they may require further information. We make sure it's fresh in the practitioner's mind so that they're not umming and ahhing during the consultation, and that the information is available as and when they need it. I also like to just prepare a little timeline in relation to how the incident took place so that the practitioner can refer back to that as opposed to flipping through their notes throughout the consultation. So now that we are at the consultation process, legal representation is allowed again, but purely in an observer's capacity. Some of the committee members know our faces by now and basically greet us and say, you know that you're here to keep quiet. And that's okay. So we're there to just observe and just to see how everything runs, because again, it informs us should anything further need to take place. After the consultation process, though, the committee generally says the determination will be made available within 2 weeks, and they normally stick to that time period. But as I say, the consultation process is just a detour because the committee can ultimately just make a determination as to whether the practitioner is guilty or not guilty of any unprofessional conduct. But please don't let me fool you. I make it sound so quick and easy, like it's just going to take place overnight. But these processes are really, they vary in terms of time periods. I've had some recently where one was finalized from submission to determination. It was finalized within 4 months. And I've had others that we're still waiting for a determination on after 1.5 years. And that's because the HPCSA is still trying to get hospital files, or they're still trying to get reports from other practitioners who were involved in the patient's treatment. So it really, the time period varies. And we often just say to practitioners that we can't guarantee a time period in which this will be resolved, but we follow up on a monthly basis so that we can keep them apprised as to where their matter is in the process. So let's move on to when a determination is made. So if the prelim committee accepts the response provided by the practitioner, they then say, response is accepted, no further action will take place. And that is ultimately first prize, because that's where it stops. Unless obviously the complainant appeals the matter to the High Court, that's where the complaint generally stops. And that is great, first prize. However, if the prelim committee finds the practitioner guilty, there are a few options available to them. Now, if this is specifically in relation to minor transgressions, I'll get onto the other point shortly, but if the practitioner is found guilty of unprofessional conduct and the committee considers it to be a minor transgression, the committee can impose one of the following penalties on the practitioner. So it's either a caution, a reprimand, a caution and a reprimand, or a prescribed fine. the minimum and maximum of which has been provided for. So you'll see here on the screen now that there's a table which provides for minimum and maximum fines. Now, bearing in mind, this is just an excerpt I've taken out of the regulations, but I'm happy to share the regulations if anybody would like a full access to the full table, because it's quite long. But here you can see, you know, in relation to advertising, the minimum fine is 2,500 Rand versus the maximum fine, which is 10,000 Rand. For negligence, the minimum is 20,000 Rand and the maximum is 70,000 Rand. Whereas for perverse incentives and kickbacks, the minimum is 20,000 Rand and the maximum is 5% of the incentive, or 20,000 Rand, whichever is the greater. So although the minimum and maximum fines are provided for, it's ultimately at the committee's discretion as to what type of fine they would like to impose on the practitioner. I would just like to point out here that in terms of the I2 MedMal policy wording, fines and penalties are not covered. If the practitioner is fined by the prelim committee and agrees to accept that fine, then it is ultimately for the practitioner to make payment of the fine. Sometimes these fines can be quite large, as you can see. I mean, a 70,000 Rand fine is not cheap. It can be paid over a period of time. Generally, the HPCSA only allows for a period of 6 months, but obviously we try and negotiate with them. So this is where minor transgressions are involved. And the good thing about a minor transgression penalty, I say good, it's not ideal, but again, we're looking for silver linings here. The penalty is then the practitioner's certificate of good standing is not endorsed. The acceptance of the penalty and the payment of the fine does not constitute a conviction, and it is not reflected against the practitioner's name as a previous conviction. The matter is then regarded as finalized. So what happens here is sometimes there's a bit of a knee-jerk reaction, especially if a practitioner's had this before, and they just want to accept the penalty and get it over with. But what happens is generally you get a letter from your investigator that says your practitioner has been found guilty of unprofessional conduct for the following. The following penalty will be imposed. And then sometimes the practitioners just want to respond to that and say yes, and they're happy to sort it out. But there's a second step to that. The charge sheet must have been received from the pro forma complainant. So the charge sheet ultimately tells the practitioner exactly what they've been charged with. And then the practitioner can make a determination as to whether or not to accept the charge that's been imposed against them and the penalty that goes with it. So I just like to caution here and say we need to take a breather, that there's no point in just responding to the letter. Rather wait for the charge sheet to come in and then respond to it after everything's been considered. So if the practitioner then obviously also has the option of not accepting the minor transgression penalty that's been imposed on them. If they think the fine is too high, or they really just genuinely believe that they that they were not guilty of any unprofessional conduct, they can respond and say, not accepting it. Now, obviously, this is subject to the instruction from the insurer as well. We don't just go ahead and say these things. The decision is made in conjunction with I2. So that's where a minor transgression penalty is not accepted. But there is another process where the HPCSA or the prelim committee rather, can say, actually, this does not constitute a minor transgression. We found you guilty. We're not imposing a minor transgression penalty that you can just accept. We're actually referring your matter to a full conduct inquiry. So this is where this leads to. If the practitioner rejects the minor transgression penalty, or if the committee themselves do not believe that the conduct constitutes a minor transgression, then those matters go for a full conduct inquiry. So these full conduct inquiries are ultimately run like criminal trials. This is where the practitioner is charged with certain counts of unprofessional conduct and is required to plead thereto. You also then have what I like to term a prosecutor, because the pro forma complainant ultimately steps into the shoes of the complainant themselves, just like a prosecutor would do in a criminal action. Then, as opposed to the matter being argued before just a judge or a magistrate, the matter is then argued before a committee comprising of 5 people. And these 5 people are 2 public representatives, one of whom has to be the chairperson, 2 persons who are registered in the profession which the practitioner is registered, at least one of whom is registered in the same discipline as the practitioner, and 1 member of the professional board. Now, just back to the discipline aspect of this, what we find here is that this is an ongoing argument with the HPCSA when it comes to the constitution of the committee, because what we say is, sure, we're representing a neurosurgeon in private practice, and you've appointed a neurosurgeon, and that's great, but that neurosurgeon actually practices, he works in a state hospital. So the 2 don't necessarily speak to one another. The neurosurgeon on the board may not necessarily have a full understanding of how the neurosurgeon in private practice works. So oftentimes we say to them, not only must it be in the same discipline, but they must have similar practices. And as I say, ongoing fight, but we generally get it right. Now, after you've run through the whole procedure of a inquiry hearing, if the practitioner is found to be guilty by that committee, then the committee has the power to impose certain penalties on the practitioner. They have the same powers to impose the minor transgression penalties as the prelim committee has, but then they also have the power to impose more severe penalties, such as the suspension for a specified period of practice. Suspension for a specified period from practicing or performing acts specifically pertaining to his or her profession. Removal of the practitioner's name from the register, a compulsory period of professional service, or payment of the costs of the hearing, or a restitution, or both. So this is what the committee can impose on the practitioner. Now, it can be concerning, and obviously the practitioners need to be made aware of the different penalties that could be imposed on them. I mean, we don't like them to walk in there blind, but ultimately that is why you work with an insurer such as I2, who's so good at what they do, and they refer it on to attorneys and we brief advocates to assist us in arguing these matters that are referred for conduct inquiries, because that way we can ensure that the practitioner's rights are fully protected. Something I would just like to highlight here is that civil matters can be run concurrently together with HPCSA complaints. So I'm not saying for I2, but for a different insurer, I've actually had it before where we've run a civil claim, a criminal trial, and an HPCSA complaint all at the same time. But oftentimes what you find is prior to instituting a civil claim, a person will actually institute a HPCSA complaint. And oftentimes they actually try and use the outcome of the HPCSA complaint to influence the civil trial. But sometimes what happens is that they're not getting a response timeously, or they just submit both at the same time. And these are technically 2 different claims. They are covered under 2 different sections of the policy. So therefore, it is perfectly acceptable to have both run at the same time. And what you will probably find is that the same attorney is appointed on both, because then the same version is used for both the HPCSA complaint, but also for the civil claim. So we've reached the point where that is a complete overview of the HPCSA's complaints process. And now I know that it all sounds like well and good in theory. I mean, there's certain aspects that are quite academic and quite technical, especially in terms of the regulations. But often, it's quite interesting to hear other people's experiences. I haven't had too many crazy ones, where you see, the facts are absolutely wow. But if you have free time, because all of us do at the moment, have a look at the HPCSA's website, because they actually publish their judgments. So they tell you what the practitioner was charged with and what the outcome was. I've seen one before where the practitioner was charged for amputating the incorrect leg. So, on those matters, I quite understand why I've had a surgeon write on me in Koki before, perhaps just making sure exactly where he's going to operate. But I've had an instance where the practitioner actually was fined 15,000 Rand. She was found guilty of unprofessional conduct, where it was said that she didn't communicate effectively with her patient, and she received a 15,000 Rand fine. And she just said, I did not do anything wrong, and I'm not willing to accept the fine. And together with her insurer, we decided that we were going to proceed with the full conduct inquiry. She was made fully aware of what the outcome could be before the committee, and she was accepting of it. We actually moved we moved through the process in a day, and we were successful to the point that they actually dismissed all charges brought against her. So that was an excellent outcome that we were very, very pleased with. But just one thing I do have to say is that oftentimes we find that the more subjective complaints are the ones that pose more of a challenge to us. When I say subjective, it's one thing to have an orthopedic surgeon who says, I performed a procedure to the patient's shoulder and this is the complications, and the complication arose, but the patient was fully aware of the complications, and you have that type of information. But the more subjective ones, where we actually have those who are practicing in the mental health sciences, so psychologists and psychiatrists, where you've got patients who have a subjective experience, or, parents who have sent their children to a psychologist and then complain about an interaction that they've had with the psychologist. That's a very subjective complaint that you have to respond to. And there you have to use all the notes available, and you respond to each and every point to ensure that no stone is left unturned. So I'm pretty sure you've had enough of me rambling on for the time being. So I would like to hand it over to the floor. If anybody has any points of discussion, questions, queries, by all means.
Thank you very, very much, Tarryn. I really appreciated the walkthrough of the whole complaint process, and I know I've learned a lot. There are just a few questions. I'm gonna tackle the first one from Nolene. She asks, is there any recourse to a practitioner who receives a frivolous Section 41 complaint? Huge legal fees are incurred, and our clients sometimes want to know if they can recover the cost from the HPCSA.
So thank you, Nolene, much appreciated. I actually have, there was a recent case, I say recent, it was last year, but there was a case that, sorry, I just trying to find my camera. There was a recent case where a practitioner actually took not the HPCSA, but the complainant to court and said that the complaint was frivolous and that it was vexatious against her. So you can't necessarily recover it against the HPCSA because they are an investigative body that's really just there to perform a certain process. But there is potential to actually recover those costs against the complainant themselves, because then you ultimately say that it's frivolous. Why would you have submitted something like this? But we haven't seen it happen in our law yet. We just know that there's a slight opening that could allow for it. But oftentimes what you're finding is that complainants are individuals. In this specific case, it was actually against a company because she was the medical doctor who was employed on site. So that made it slightly different, because then you're dealing with a company that has much larger funds, as opposed to an upset patient who may not have the cost to cover their next medical appointment. So it really just depends. We haven't seen it happen yet, but I think that there is scope to do so.
Okay, brilliant answer, Tarryn. Thank you so much. The next question that I have here is from Letu Jacobs. He would like to know, what's the highest fee you've seen when dealing with a complaint, excluding a fine?
Sorry, the highest fee. So are we talking?
Yeah, I'm not sure. I think maybe it could be highest payer.
So this is the thing, is that HPCSA complaints don't, it's not the same as a civil claim. The civil claims are very different. I mean, the payouts there too, if we're honest, go and have a look at any case law in relation to a child who's suffered an injury at birth. I mean, 24 million, and up. But with HPCSA complaints themselves, there's never an order. Well, I say never. There is obviously scope for restitution to be paid, but restitution is not a penalty that we've seen imposed terribly often. We see more of the fines, and the fines that the fines can be enormous. I mean, I've seen one recently for incompetence and negligence. Incompetence, I think, received 50,000 rand, and negligence received 70,000 rand. So the fine itself came to 120,000 rand.
Sure.
So, and
That's
for an
huge.
individual to be making payment of that, I mean, that's huge.
It is crazy. But thanks for that explanation. The next question comes from Jacqueline Taylor. She's got a full-on scenario, so please just humor me as I read through it.
By all means.
She says, my mother was left for 24 hours without food or water in a hospital bed, without being taken for her surgery, and also without communication from the doctor or nursing staff. The doctor scolded the nursing staff for forgetting her mother in the ward and putting the incorrect ID bag on her wrist. How do I lodge a complaint of this nature?
So the thing is that it's not, and this is the interplay between our private hospitals and those who are employed and not employed. Doctors, I'm assuming at this stage it's a private hospital, but I'll also just touch on the state one as well. So essentially here, doctors are not employed by private hospitals, or that is the rule. That is the rule as opposed to the exception. There are a few exceptions, but I'm just speaking to the rule now. So generally speaking, doctors are not employed by hospitals. So what we found is, and you'll see this in the civil claims, where you'll have the hospital that's sued, but then they cite the doctor as the employee. And that's not the case. So there are two separate entities. Doctor is a contractor to the hospital. So if you were to lodge a complaint about the nursing staff, it would actually have to be lodged with, I would start with the hospital itself, but also then it can be sent to the Office for Health Standards Compliance. So they are the OHSC, and they deal with generally complaints in relation to hospitals and nursing staff. You can also lodge a complaint with SANC, which is the South African Nursing Council. But here, I mean, it's the doctor is responsible for the treatment of the patient. You might want to find out why there was a delay in lodging as to why the doctor didn't take your mom in timeously, but it could have been for a number of reasons, that he might have had other emergencies, whatever the case is. But it's ultimately up to the nursing staff to ensure that the patient is treated in the hospital ward. So that's so you need to draw the distinction between the doctor, nurses, hospital. But generally speaking, our hospitals, facilities in general, take these complaints quite seriously. So lodging a complaint with them directly sometimes actually yields better results, because they like to know what's going on. They don't have oversight over everything, and if they know that there's a problem, they generally sort it out.
Sure. Thank you so much for that, Tarryn. The questions are flowing in, and I'm just trying to make sure that I get to all of them. We've got another interesting case from Deborah. She says she was sent to the theater without being awake. She ended up in ICU due to the complications with breathing and SAPS levels. Is this seem to be negligence?
Oh gosh, unfortunately, Deborah, as a legal practitioner, I'm going to give you the answer that most of us give. It depends. It could quite possibly be, but unfortunately, without having sight of the hospital file, and also I'm not necessarily a medical practitioner. Sometimes I wish I was, but maths was never my strong point. So I think that it would probably be best to get a hospital file, get your full file, and ask a doctor whether or not there seems to be a problem with this. I mean, the thing is, it does sound unusual. I won't lie, but unfortunately, I'm not in a position to necessarily express a comment on it without having seen everything. So I would then recommend seeing someone in the same sort of discipline who can then advise whether or not that was irregular.
Okay, thank you for that one as well. The next question is from Helene van der Poel, and she asks, are there any instances where a complainant is obliged to approach the HPSA before first proceeding with a civil matter?
As to the best of my knowledge, there isn't really any obligation on the complainant to do so. So it's not like, when we litigate in insurance and we say, oh, there's an arbitration clause. You can't just approach the court. We should have gone to arbitration first. It's not necessarily the same sort of thing. There isn't an obligation on them to approach the council first. They can litigate as they see fit. So they can actually, as I say, they can submit them simultaneously. They're not required to submit a complaint prior to instituting a claim. So no, that's not really a requirement.
Sure, very interesting. There is a question here from John Kirby, and he asked, do all members of SANC have to have PI med-mal cover? FIA has responded and said that they should have cover in place, but having the cover is actually a different topic. Are we looking at a system, if it's not in place already, where all SANC members should have cover? Or is it still a matter of whether they want cover or not, they have the option?
So this is actually, we had it with the medical practitioners a couple of years ago, where the legislature actually wanted to amend the Health Professions Act that required all medical practitioners to have insurance in order to register with the HPCSA and therefore enable them to practice. So we've had that with the medical practitioners, but can I tell you that all fell apart a couple of years ago because and one of the other competitors in the market raised an issue because they're not technically an insurer, they're an indemnifier. So that actually became a bit of an issue, and then it was just never carried through. But in terms of the SANC members, as far as I understand, they're not all required to have cover, because oftentimes, it's slightly different to the doctors who are, just like doctors who are employed in the state. Those doctors are actually employed, as opposed to in the private sector. But in all areas for nurses, they are generally employed unless they are acting as sort of wound care sisters or midwives, or any instances where they act for their own account. But where nurses are generally employed by hospitals, the cover is already extended to them, in that any claim that is brought against them, they are an employee of the hospital, so therefore the hospital's cover will ensure that they're covered too. So there isn't anything in our legislation that generally requires all nurses to have cover. They're the same as the medical practitioners. It's how do I want to put it? They say it's a good thing to have, but that's certainly not a requirement.
Sure.
Hi, Tarryn.
Hi, Fia.
How's it, guys? Just to perhaps come in on the topic. So many of the organizations do require their nurses to have it from a limitation of liability, but not necessarily a requirement of legislation. So if a nurse is working part-time or moonlighting at a facility, many organizations do require those individuals to have their own indemnity in place. But again, it's not legislation for them to have it. Just with any practitioner that's having admitting rights to an institution. Very similar. They have to have their own cover in place.
Thank you very much, Fia.
Thanks.
Tarryn, there's a comment made from Baile. She says her aunt's lungs, instead of operating on one lung, the doctor decided to operate on both lungs. And that instance happened in 2010. So I think the question that I'd like to ask on that comment is, how long does someone have to lay a complaint after an incident has happened?
So there's no prescribed time period. In terms of the HPCSA's legislation, there's no time period that forces you to lodge it within 6 months, a year, whatever the case is. That is really, it's quite an open period. Obviously, a claim is slightly different because you have 3 years from the loss arising. But in the general, and that's just generally speaking, that's a whole topic all on its own. But in terms of the HPCSA themselves, no, there's no set time period. But it does generally become a bit more difficult because the records aren't available, or I say they aren't available. Maybe the person who you were dealing with at the time is no longer around, or whatever the case is. But you certainly can do so now. There's no limitation to you doing so.
Okay, fantastic. There's a comment made from Michelle Williams, and she asked, if you're a victim of medical malpractice, where do you institute a civil case? Do you do this at the magistrate court or in the high court to claim for damages?
It really just depends. So damages in the magistrate's court is limited to 400,000 Rand. And then from 400,000 Rand up, it's in the High Court. Generally speaking, medical malpractice claims don't fall under the 400,000 Rand mark, but I say that we've settled for much less. But with that being said, I mean, it's ultimately up to the attorney who's dealing with it to know which jurisdiction they need to place it in. And sometimes your matters of such a nature that it's more complicated. So it may not be the quantum that's claimed, so the amount that's claimed, but it's actually got to do with the complexity of the matter. And you actually may want a judge to hear it as opposed to a magistrate. But that's ultimately up to the attorney who's dealing with the matter. But can I tell you, I haven't received terribly many medical malpractice claims that stem from the Maj Court.
Okay, cool. There is a hand raised by Devika. Devika, I don't know if you'd like to ask a question. Devika, are you there? Okay, maybe she'll just type her question in the chat box. Mary Grid says, is there a prescription period to submit claims? And I think you've just tackled that question.
Yes, it does. So it is, however, slightly different if you've got, because as I say, this is a whole topic all on its own, but it's when you become aware of the claim. So what you'll find though is a lot of claims are instituted for children who suffer brain injuries at birth after a long period of time, and that's why obs and gynaes have such a high premium. It's because it can take, sometimes we've seen it 10 or I've got one at the moment that's 14 years later. And that's because they can say that they weren't aware that it was a brain injury at the time, and only once they became aware did prescriptions start to run. But even in the case of minor children, it's not until they turn 21. But in respect of mentally deficient persons, it's generally that prescription doesn't run against them. So but as I say, this is a discussion all on its own. Yeah,
it's that chat with Tarryn Venter session 2.
2.0.
Devika, are you able to speak and ask a question?
Devika said it was an error, so don't worry.
Okay. Okay, cool. Thank you so much. I don't see any other questions, Tove. Are there anything coming through on Teams?
So I've posted all the Teams questions on the chat, and you have covered them. Just lots of thank yous and lots of very informative, and thank you very much, Tarryn.
Thanks so much, everyone. I do just want to end off because I've got some takeaways for everybody here. Hey,
McDonald's.
So this is the thing is I want us to bear certain things in mind when dealing with HPCSA complaints, because oftentimes, we think that it's important to notify of claims immediately, but HPCSA complaints really are just the same. So practitioners must notify as soon as they receive an HPCSA complaint. I think it's also important to let them know that, it's Section 41A investigations are possible and they may occur, and what they should do in that instance, but also what to advise their staff of. I mean, Poppy is such a hot topic at the moment that, it really is important for them to know what information they can give out and what information they can't. And when in doubt, defer to the practitioner. Yeah. Also, in terms of the I2 policy wording, complaints processes are covered, the expenses related to that, but fines and penalties are not. And just one last thing, something that I really think is important to bear in mind is that we're ultimately dealing with individuals here. These individuals are having their intentions and actions questioned, often by people who use emotive language and make inflammatory remarks. It really can be a terrifying and stressful experience for them as well, considering that they're having their reputation and their good name placed in the balance due to an unhappy patient. So I think the important part of this is that there's a human aspect. And the fortunate part for all the brokers on the call is that you're dealing with an insurer like I2, who has this at the forefront of their mind. So I think that's just something wonderful to take away. So thank you very much for having me. I insist on showing my own picture here. Look, my hair grew. But this is my email address. If you would like to get hold of me, if you have any queries, please do not hesitate to contact me. Always happy to help.
Tarryn, thank you so much for such an informative session. We really, really enjoyed it. If there are any other questions or if something comes up later on, please feel free to reach out to any one of us at I2. We will be happy to assist you. Tarryn, thank you so much for your time and have a fantastic day.